too numerous to list, quite frankly. And luckily, Anonymous puts them on their website, so if we forget one, we can go back and find it. But the reality is they recruit members through electronic communication. They distribute attack tools, hacking tools. The LOIC tool is one that's been very commonly used. These are distributed through electronic communication, stored in manners around the world through electronic communication. So this whole group, which is attacked dozens and dozens of targets, would not exist without this framework. It just wouldn't exist without the framework. So it stands to reason that without the ability to collect electronic communications and electronic evidence of all sorts, and I'm talking not just about communications, they're very important, but also about logging data and various other things like that, which are not really the main subject matter of Title III's, we would have very little chance of prosecuting them. And instead, because we've been able to do that, we've been able to take tremendous steps against them.
Yeah, of course, please.
You're doing questions sort of as we go along. So I know Kevin has a question. I have a question first.
Sure.
So, you know, we were talking earlier in the day about the different standards, as you've mentioned, the Title III wiretap standard, and then all the different standards under pen register and stored communications and the, you know, email standards. And, you know, I think a lot of us agree that the Wiretap Act standards for phone and bugging interceptions are the gold standard, and at least I've argued that's exactly what we should have for a large range of surveillance. So when you say, you know, it's interesting, you know, particularly Matt, when you say, look at all these things we do, you know, absolutely, those are great things, the minimization requirement, the last resort requirement, the judicial oversight, the suppression remedy. And I think that, you know, my question, which I guess, you know, it would be nice if you could address, and segues from your last point, is why is it that for all the other information online that is developed in the last 20 or 30 years, law enforcement and Justice Department resists those kind of standards and protections applied to the new information?
Well, I think it's because the information that you're referring to is not monolithic. It's not all of one type of information. There's some information that, you know, goes generally referred to as subscriber information, which is sort of the equivalent of the customer list or a subscriber list of a magazine. And to apply a probable cause standard to something like that, it does not comport with pre-cyber law. It just doesn't. And unless there's a reason to do that, it's going to interfere with investigations. We really can't go through all the various different types of evidence and sort of lay out why each one is handled the way it is. But the main thrust is that content is handled with, it requires a greater amount of information to obtain probable cause, and real-time content is even above that. And so when you go through the different kinds of information and look at what you're trying to obtain, is this a log file of a company that has a website and was attacked? Well, that's their record. How do we obtain records from companies? We send subpoenas to them. And then we have to defend that subpoena if the recipient moves to quash it. We have to defend it on overbreadth or whatever it might be. But there's a corollary in the real world, and most of the electronic communication evidence does have some sort of corollary. But the main thrust, the main concept is there content in it? In other words, is there content, is it an email that has content within it, or is it some sort of communication? Are we capturing the content? And the second question is, are we capturing it, are we looking at it historically, or is it captured in real time? And that's the only way to make a rule as opposed to having no rules and just deciding every single one on a case-by-case basis.
And I'd just like to add that, I mean, you heard this, I think, from Jim during the keynote, which is, it's not like law enforcement knows who to go after in every case and comes with probable cause established. So you really do need to have this sort of incremental scale, and where those lines are definitely the subject of this kind of debate. But the reason for that is not that we're just saying, oh, we'd like to have it be easy. It's that if everything was required to be at the gold standard, we're not going to be there. We're going to be stuck with doing Google searches and voluntary interviews, which people can say, rightly say, no, I don't want to talk to you, which is their constitutional right. So the issue is, what kinds of tools can you have where you don't have to make that sort of gold standard showing, so that you can develop the probable cause for the more intrusive kinds of communications. You heard about the Third Circuit case, and it's a really good example because, ironically, in that case, as you kept on hearing, there's no defendant. That's because we didn't know who to go after, and that's because the whole idea is that you use the building blocks to figure out, yes, you know there's a crime, or you think there's one, but you don't know who did it. So you need to have a way to start building and going up that ladder. And then one final point on that, which is, there's been a lot of discussion about ECPA, and this is probably not to get you focused on a new topic, to focus on in terms of retrenching it, but it's worth noting that since I was trained as a federal prosecutor about 20 years ago, and I just use grand jury subpoenas for everything, a grand jury subpoena makes all of this debate look, it kind of dwarfs it. So you can get all of the things that you're worried about that go into privacy, and I'd say legitimately are raising these issues, are things that in many cases you can get with a grand jury subpoena, which the Supreme Court has said you need to make no showing, precisely because they agreed that the whole idea is that that's a tool to develop probable cause, not that you need probable cause or reasonable suspicion beforehand. And you can get diaries. You can call people to the grand jury to talk about the communications that we're all talking about. How do you protect it if it's written down in an email? Well, if ECPA can change that standard, but you can still use a grand jury subpoena and say, now you're going to come to the grand jury and you're going to tell me about the communication you had with the target. I mean, so the kinds of things that you can get with a grand jury subpoena are just enormous with no showing at all.
Brian, anything?
Well, I'd just say, from the standpoint of a private sector lawyer who counsels companies that sometimes get asked by the government to do things, and my clients these days are more downstream and smaller than Google, so Richard could probably comment better than I could, although Google, we are available, our firm is, if you need anything, any more help, is most of my clients, I mean, obviously there are extremes at the end of the scale, but most of my clients are much more concerned with having the standards make sense and be predictable and be consistent than they are with what the standards are. I mean, people talked a lot today, and Paul had his various eye charts about how confusing the statutes are. They're also inconsistently applied all over the place. And so, getting back to the question of, wiretaps for white-collar crimes, the last thing I would want on behalf of my clients that have to work with the government is yet another balkanization of the standard. In other words, a different standard for an SEC fraud case than for a drug case. So just from that standpoint, that doesn't really even get at the privacy or constitutional questions, but predictability, consistency, and having the rules make sense is really important to the private sector.
There's a question over here. Yeah, I did have a question.
Testing. Well, first off, a thank you for coming and letting yourself be subjected to questions from privacy advocates. It really is appreciated. I, like Susan, was a bit puzzled by the initial focus on wiretapping, when what we've mostly been talking about today is stored content and location information that often isn't content. And I was particularly thought it odd, the reference to the wiretap report, to the extent that, in the last wiretap report, it was clear that there were at most 6 law enforcement wiretaps for internet communications, which would indicate that the vast majority of access to internet content is through stored content, although I suspect there's a great deal of collection that I would characterize as a wiretap that currently the FBI doesn't. Putting that aside, this leads to my question, to the extent we have these reports for wiretapping, but it's clear that wiretapping is not the main mode of collection for internet content, nor is it the way that you track location, the two topics that we've been discussing today. Doesn't it make sense to have similar reporting about the numbers regarding 2703D orders and pen register orders, so that we have some greater transparency about how often the government uses these investigative tools? That seems a reasonable request. I'm wondering, instead of asking, can you please defend the 180-day rule, can you please explain why we shouldn't have those numbers like we have those numbers in the wiretapping context? And thank you in advance for your answer.
I just can't wait to do more reporting. I mean, look, I'm new to the FBI. I've been there for a little over 4 months. The number of reports, I mean, I keep on thinking we're the most transparent, certainly it seems like for the intelligence community, we're the most transparent agency there is, because there seem to be public reports on almost everything we do. I think the very simple answer is, there's only so much time. I know this is going to sound awful, but there's only so much time in the day. We don't report grand jury subpoenas. Those are far more intrusive than a pen register. There's Supreme Court cases talking about the limited nature of a pen register, and grand jury subpoenas are going out. Just using my own experience, I had a computer, I had a printer that meant unlimited grand jury subpoenas. And so, the idea that you would have to have a tracking system for every grand jury subpoena, every trial subpoena, every pen register, I mean, I just don't think that's getting at what is really the most important, or the things that are most critical from a privacy point of view. I mean, grand jury subpoenas get at data that is far more intrusive, and that is not being monitored, and I don't think it should be. But I mean, you can go ahead and get tons of employment records, diaries. You can call witnesses to the grand jury. That happens all the time. So to single this out for more reporting doesn't really seem that.
Wiretaps. I mean, grand jury subpoenas are so invasive. Why would we bother reporting anything?
Well, we do report because when we go to court for wiretaps, there actually are. That to me is, to use Matt's analogy, in terms of there are many factors when you're talking about content of sort of ongoing, sort of prospective communications. That's where there's the highest sort of judicial standards and judicial oversight, and that's where there's lots and lots of sort of reporting about what's done there. But I think a lot of this is line drawing, and to me it just wouldn't make a lot of sense to pick something that I think is lower on the totem pole in terms of the invasiveness of it from a Fourth Amendment perspective.
So there's a couple of other concepts that we should at least chat about, because I think they play into your question. As I said before, the underlying core concepts are content and real time, content versus non-content, and real time versus historical. The reporting requirements, and just be clear, these aren't, I wasn't referring anyway, I'm not sure we were using that term in the same way, that you're reporting to the reporting requirements of the number of wiretaps. I'm referring to the actual reporting requirements within the wiretaps of informing the court, which is called the reporting requirements.
Earlier, Andrew had been talking about the wiretap numbers, so that was what.
Right, okay, but that's different than the actual reporting requirement contained within the wiretap statute, which is not a statistical number, that's a qualitative report that's made to the judge, and that's not what you're asking. But the point is, wiretaps are kept track of because they're generally expensive and lengthy, and they hit both of those core concepts: content, real time. The other items that you're talking about, a 2703D order, well, when you look at what it's collecting something that is, depending on what circuit you're in, not content and not real time. Those two core concepts don't come into play, looking at something that has far less intrusiveness. I'll say one word about grand jury subpoenas. Grand jury subpoenas are wonderful tools to open up investigations. First of all, unlike many of these other concepts, they are, the issuance of them from the government standpoint, not from the recipient's standpoint, but from the government standpoint, they're covered by secrecy rules. And the contents of the response that we receive are covered under Rule 6A, secrecy rules. So there's a built-in protection for any grand jury subpoena. Secondly, while grand jury subpoenas can be used, you could subpoena a person to the grand jury and say, and by the way, bring all your emails to Joe Bad Guy, print them out and bring them in if you have them, and that would be perfectly legitimate. One of the concepts is that that person has the opportunity to contest that grand jury subpoena. And so when you're talking about the scope and the intrusiveness of grand jury subpoenas, there's a check to that. Other things like a wiretap or even a search warrant. The search warrants that go for email accounts, depending on the ISP, the account holder is not notified. So they have no opportunity to contest that until after the collection. So that requires, the check on that is higher probable cause, higher showing required. So all of these things are various balancing acts, and as Andrew says, there's a certain amount of line drawing because, you know, we can't have no lines, otherwise there's no way to judge what the government is doing, whether it's right or not.
Well, I've written and approved testimony and statements of administration position on this exact question for two different administrations, one Democratic and one Republican, and I'll tell you the words used were almost exactly the same, which is those kind of requirements are exceedingly burdensome on the human beings who would maybe be better spending their time going out and arresting bad guys and preventing attacks, number one, and number two, if the reports get to a particular level of substance, they can reveal sources and methods and law enforcement capabilities that, if disclosed publicly, even inadvertently, can cause a lot of damage to national security. And my guess is those two factors are still true in 2012. But it's ridiculous that they're still true in 2012. There is technology available that could generate these reports, track these statistics, strip out the sensitive information, take out the personally identifiable information, generate the reports where 15 years ago it would have taken 50 people to do it. It can be done with a mouse click now. Footnote, I represent one of the companies that build that technology. So factor that in, but I also, that lets me know that that's just a fact. And as a matter of fact, I think the future is likely to include increasing judicial and congressional oversight in exactly this way. Although there's separation of powers issues, and I'll probably be in an administration 5 years from now and argue like hell we shouldn't have to do it, but I think this is how oversight's going to be conducted in the future, where magistrate judges and district court judges can oversee this process through the use of near real-time or real-time statistics that don't violate sources and methods and don't take the time of agents.
I would sort of agree with that, in that I think that as it becomes easier to collect the numbers, that you'll have more congressional oversight. I don't think that there necessarily will be more judicial oversight over numbers. I can tell you now we don't have that software. So the idea the idea that every field office in there are 36,000 FBI employees, there are that many more sort of DOJ employees, and there's so many people doing stuff, and there isn't one centralized system where every time you do something, it just automatically clicks on. But I do agree that you're seeing this just in the Jones case, as technology advances and things do become more automated, the idea of tracking numbers and as soon as it becomes much easier to do, the arguments for why it shouldn't be done, become diminished.
Judge?
In my in my prior life, I was a civil litigator, and before we filed any lawsuit in federal court, we filled out what was called a civil cover sheet, basically answering 8, 9 questions about basis for jurisdiction, the statute, the type of statute you're suing under, other very basic information about a lawsuit. That is the information that the AO uses to generate reports on the work of the federal courts and what kind of caseload we have in the various areas. I'm wondering why we couldn't do a similar type of cover sheet for warrant applications. A warrant cover sheet, with the idea being just answer maybe 5 or 6 questions. What is the requesting agency? What is the type of electronic surveillance order you're seeking? Is it a wiretap or 2703D? Is it for email or phone records? Or pen, you can develop a little checklist, and then the requesting agency with the crime that's being investigated, and then have it signed off on by the prosecutor. I mean, how long would it take for one of the AUSAs in your office to do that checklist?
Well,
It seems to me once we get that information then goes into the court system. And then we can generate reports to Congress or whoever aggregating the information. Now, the level of detail obviously doesn't and shouldn't reveal, the underlying investigation or have any sort of identification information in there, but it seems to me that's a relatively simple fix. Maybe it will cut out Mr. Cunningham's client.
No, we can work with that.
But, it's just a matter of checking a box on a sheet.
Well, the only thing I can say is, there is almost exactly that already in place for search warrants. There's a search warrant cover sheet that is, it's not standardized amongst all the districts, and that really has to do with the judiciary, because different district courts in different districts say, no, we don't like this form, use this form. But within, say, Northern District of California, you go look at a federal search warrant, on the front of it, on the front of the affidavit, there's an application affidavit cover sheet, and it, in that one page, summarizes what we look to search for. And in the case of, say, an email account, it would say, in the matter of the search of an email account, Joe Blow @gmail.com, located on the servers of Google at blah, 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 blah. And then underneath it, it'll have the statutes that it's, we're alleging there's probable cause that there's a violation of, who the agent is, what his agency is, who the AUSA is, and who the judge is. It doesn't contain the probable cause itself. That'll say, see attached affidavit.
Is that information sealed?
Well, I was just going to bring that up. Very, very often, that information, there's a sealing order on it. And later, almost all of these get unsealed at some point in time. As far as things like 2703D orders, those don't have that. Grand jury subpoenas, most U.S. attorneys' offices track them themselves, just within each case. So if I have, a case, an anonymous case, I'll have all the grand jury subpoenas issued for that. But again, the judiciary never sees those subpoenas unless there's a motion to quash.
Yeah, well, I would be asking about those subpoenas. I would be asking about the orders. When the court is asked to open a case file, a magistrate judge case file, or a miscellaneous case file, it would just become a matter of the court record, and it ought to be something that the information is general enough where it can be made publicly available, and that would be a relatively easy way to aggregate the data to facilitate the reports that we've been talking about, that Kevin mentioned. And I know, so I just kind of actually, I understand that probably the courts don't need legislation to do that if they don't want to, or, we don't have to wait for that. But of course, 95 or however many districts there are 95 different ways of doing things. But just your reaction to that.
My view doesn't sound bad, other than, having been in Washington long enough, it sounds like once you're going to have a working committee, which means that about 2 years from now, it'll work. I mean, I do think technology, that sounds like a logical approach. I do think the more that things are automated or centralized, the easier it is. So, the FISA court here has jurisdiction over all national security wiretaps. So it is easier for that court to be keeping records because everything's centralized and everything goes through ultimately the same group of prosecutors. So you have an easier way to track things and have oversight. It is harder when you have 50 states, U.S. attorneys who are very independent, AUSAs who are even more independent than their U.S. attorneys. So it is a difficult process to coordinate. But I think it will happen. But I just think it's one of those things where it's like the answer is, yeah, it sounds great, but it's a logistical issue.
Well, the Department of Justice can track my hours, and they track my leave, and they track my sick time. I really don't think that it's an impossibility that they could count the number of search warrants from each district. What that is going to tell us, I don't really know. It might be a statistic that is less illuminating than we thought.
Right.
Another question before we move? A couple questions. All right. Fine by me.
Hi, Mr. Weissman, you and Mr. Dempsey both emphasized what a game changer Jones seems to be. Would you elaborate some on what the implications are for the jurisprudence, for the Justice Department's positions and strategy? And would you respond to what Mr. Dempsey said about the implications and about what it means about the advisability of the Justice Department negotiating changes to ECPA with somebody? He didn't say who, but we can guess.
So as I mentioned, the Jones decision, I think, really changes the landscape. So the majority on the trespass theory, is I think some people thought before the case came out that was at least one possible line drawing for the court. Some people said that it was an idiotic one, but because it doesn't make a lot of sense, as Justice Alito, in more polite terms, agreed, that's just, it really doesn't quite hit the line right, which is why people thought the court wouldn't go with that, although it's easy. It's sort of like the Skilling on a services decision. It was, it's not the best test, but at least it's clear. And so the majority opinion raises problems for law enforcement, because if trespass is the theory, and now that's the holding, the issues, there are many, many types of techniques that law enforcement uses. So here's a sort of very low-tech one, which is a trash cover. And a trash cover is when you go and you look at someone's trash. Well, if you open up the lid under the Scalia test, and he's very much like, you do a search and you touch the stereo 1 inch to look behind it, that's a violation. So lifting up the lid of the trash cover is, the thing that we are wrestling with now. The second part is what do you do with the 4/5 concurrence, where you have 4 justices having a reasonable expectation of privacy rationale, and a 5th justice who, for whatever reason, did not sign on to that. I have my suspicions as to why. But you have 5 justices who are saying they agree with the reasonable expectation of privacy rationale, one of them actually going much further than the 4. So from a law enforcement perspective, even if it's not technically a holding, we have to anticipate what's going to happen down the road because we want to protect our investigations. The kinds of issues, and this memo, which is probably going to go out either today or Monday, and I'll talk about it in a second what the department's doing, is